Okay, I'm gonna incorporate some help and I'll be right back. All right, just one more minute. I think I'm gonna have Elizabeth share my slideshow. I've been helping with the technology and now I need the help. Okay, we're gonna go to Plan B. Renee, could you share my slideshow for me? It's available on OneDrive. Awesome, thank you.
Not a problem. Just let me know when you need me to advance.
Okay. Okay, well, my name is Mark Weicker. I am going to present today on the 2025 Students' Point of View, an updated perspective on student challenges. Just a little bit about me. I am in the firm's Columbus office. I am married to Courtney. I have two kids, Kennedy, who is 13. She'll be 14 on Monday. And my son, Weston, who's 10. And a couple fun facts about me. I I love blue cheese crumbles, and the moldier, the better. That's one thing. In college, my favorite job ever was being an ice cream truck driver. And I'm also a former school side attorney. So right out of law school, I practiced on the school side before we opened the firm back in 2013. So 2014, I'm sorry. So 11 years, we're 11 years in with the firm and used to be on the school side. So a couple fun facts about me. Next slide. I'm going to start with a story. And this is a story about Tessa. That's not her real name, but this was a former client of ours. And Tessa was 15 years old. Tessa was dating a boy in her high school who was 16 years old, and they attended a rural school in the state of Ohio. Tessa was a freshman. She had been dating this boy for about 3 months, so relatively new. And the boy, through a series of texts, encouraged Tessa to send a topless picture. And she had contemplated it. It had actually been over a series of a few days in text that he was encouraging her to do this. And she talked to a friend about whether she should do it. And it's just a side note. The friend suggested that if she do it, she not include her face so that she was not identifiable, which is actually a good tip. Not that you would want to encourage any minor or person to send a topless photo, but it is helpful if you're defending situations like this that it does not include a face, because that's obviously much more identifiable. In any case, Tessa did share that photo with her then boyfriend. They dated for another 6 months or so. And Tessa, went on about her business. She was now in her sophomore year at the high school, and they had broken up. And a few months after they'd broken up, the boy, her ex-boyfriend, showed the picture to some of his friends, which of course is the problem with sending a picture like this. It exists forever. When those boys were sharing and talking about the photo, a parent was in the room. And keep in mind that Tessa's boyfriend attended the same high school, and these boys also attended the same high school. And when the parent heard what happened and who it was, they knew who Tessa was. They sent the information to the school. The school felt like they had an obligation to send it to law enforcement. And then Tessa and her boyfriend found themselves the subject of a suspension with a recommendation for expulsion, and found themselves with criminal charges in juvenile court. So I just want you to contemplate Tessa's actions just for a few minutes. And I'm going to step back from this story and move on. But just think about some of the decisions she made and challenges that she may have went through in this whole proceeding. All right, next slide. I like to provide this chart because it's pretty illustrative of where we've come. Now, I just want to identify the chart at the moment. Notice that we go from 1973 to 2023. And these are the rates of suspension expulsion nationwide among K-12 students. Keep in mind too that at the end of the chart, there's a shorter span of years, 2019, 2021, 2023. That's a relatively short amount of time. Otherwise, it's jumping from decade to decade. But you can see that suspension expulsion rates reached a peak in 2010 and then had a pretty significant drop to 2019, and then another pretty significant drop through 2020 and 2021. And what is obvious on the chart is that we have this increase through the last year for which information is available, which is 2023. This information comes from the Civil Rights Data Collection Office at the U.S. Department of Education and was considered and combined with information from the Learning Policy Institute. Okay, next slide. All right, Elizabeth, if you could share my poll question. Now this, you'll have to scroll down or make your window a little bit bigger to see the answers. But the question is, why do you think more middle and high school students are suspended, expelled today than in 1973? And it's about twice the rate of suspension expulsion after that big drop. And go ahead, there are no right answers or wrong answers at the time. I just want to get an idea for what people think the reason is. We'll give you about 20 more seconds to answer. All right, about 10 more seconds to answer if you haven't already. Keep in mind there's a not sure answer at the bottom if you're not sure. Okay. So here we have teachers, administrators are less tolerant of negative student behaviors. 48% of our people who responded indicated that. It was multiple selections, so parents do not monitor social media phone use very well. There's been an increase in teens needing mental health related supports, and then increased academic pressure and standardized testing. And then a few answers down below, including 4 who responded not sure. Okay. All right, you can close that, Elizabeth. Thank you. All right, next slide. So we're going to talk a little bit about why there was this drop starting in 2010 and why we see an increase from the later 2010s to recently. So some of this you've heard of already today or yesterday. Some of the presentations included or touched on restorative justice and truancy today in particular. But one thing that happened and if we can go, let's go forward one slide if you don't mind, Renee. So you see in 2010, again, that was a peak, and then we have this pretty precipitous drop from 2010 to 2019. If you didn't guess already, the bigger drop from 2019 to 2021, rates plummeted really in 2020 and 2021, that school year in particular, because most people or many students were not in school for the entire school year. And if they were in school, it was this hybrid model where some were and some weren't. So that the explanation, I'd say that largely the explanation for that drop from 2019 to 2021 was COVID, and that students were at home rather than in school. But that drop from 6.9 to 3.7, a big reason that happened is because there was an concerted effort on the part of the executive branch, in particular the Obama administration, to identify alternatives to suspension and expulsion and reduce the rates. So you'll see that in that period of time, the executive branch shared data regarding the impact of suspension and expulsion. So the data piece of that would be information that showed, and this is consistently the case with the data on suspension and expulsion, that the only thing that makes it more likely that you're going to engage in conduct that violates the code of conduct, or that you're going to be removed from school in some way, either through another disciplinary event or a dropout, the only thing that makes that more likely is a suspension or expulsion. So removal from school makes it more likely that you're going to be removed from school. So the data that was shared starting in 2010 encouraged schools to look at alternatives based on that data. The other thing, and I know most of you know this, that data showed and distributed to districts around the country that suspension and expulsion disproportionately impacts students of color and students with disabilities. It also disproportionately impacts male students. So if I had a line on this chart for the rates of suspension and expulsion for Black students and for students with disabilities, it would be roughly double. The line kind of tracks perfectly with this line in that the rates are roughly double the rates for the general student population, despite the fact that the conduct isn't double. So it's a disproportionate impact just because of internal bias of those who are doling out the discipline. So that data was shared among school districts. Lots of alternatives were proposed. And then, one of um, the one thing that flowed from that is school districts started using restorative justice. And restorative justice is an alternative. It's one of several alternatives to suspension expulsion that were proposed by the executive branch at the time. And that's getting the parties together, identifying the issues, and then ultimately, coming to a conclusion and learning from the situation. One of the things, like I mentioned, that the data showed is that not only does suspension expulsion make it more likely that you're going to be excluded from school in the future, it's also not deterrent. It doesn't deter bad behavior. So restorative justice is a way to take the situation, have the parties, sometimes in person together, confront, the conduct and how it impacted someone, and then move forward in a learning capacity, which all seemed to make sense. I remember when we were doing suspension expulsion hearings in that time before COVID, we would have Exhibit A, being the information from the executive branch. And there was a Texas study done that showed the data. And then there was even the Ohio State Board of Education had adopted a resolution encouraging districts to look at alternatives to suspension expulsion for the very same reason. So that's one thing that happened in the 2010s that caused that nice drop over the edge from 2010 to 2019. Then if we look at COVID in particular, a few good things came from COVID. Work from home came from COVID. I think people enjoy that. I think I enjoy curbside pickup of my, things I have to pick up from Target. Grocery delivery is another one that I think people have held on to. But I would say one of the best, if not the best, practices that started during COVID is that schools were forced to create online academies. So these are public school districts created online academies. And Renee, we can move forward. I'm sorry, backwards one slide. Thank you. So in our suspension expulsion hearings prior to COVID, it was often difficult to find an alternative to suspension expulsion when the school's interest was to remove the student from the classroom to protect other students or staff members. And sometimes that's the interest they have. They don't necessarily want to suspend or expel in terms of not allowing the student to complete their coursework or fall behind academically. They just, for appearance's sake, need the student to be removed from school for a period of time, sometimes to protect other students, sometimes just for appearance's sake, to make sure that other parents involved or victims believe that the school took the situation seriously. It was always difficult for schools to deliver the education to students at home before they had these online academies. Really, the only online academies that existed before 2020 were charter schools that were specifically online. Public school districts, with some exceptions, did not have the ability to deliver content online. So that happened, and it helped a lot following COVID, because that's now an option for almost every single school district to deliver the same content, educational content, online. The next thing that's happened, and this is nationwide, including in Ohio, that there are limits on the suspension expulsion of the youngest students. In Ohio, you cannot suspend or expel a student in kindergarten through third grade, with some exceptions for dangerous behavior. That's bringing a weapon, a gun or a knife, or making a bomb threat, or acting in some way that would be a crime if you're an adult. Otherwise, you can't suspend or expel K through 3. Now, the same statutory limitation doesn't exist in Pennsylvania and Michigan, but as you heard earlier, there are a list of 7 factors in Michigan that have to be considered. And those factors include the student's age and whether or not that student has a disability. So it is worked into the statute, although it doesn't prohibit the suspension expulsion of the youngest students. So that's been a positive. And then limits on truancy. You've heard this in Jacqueline's great presentation today, where it compared the states and showed that Ohio has this model that it uses where it limits the referrals to juvenile court. But Ohio also has a prohibition on suspending or expelling a student based solely on their attendance. So, and this has happened in several states nationwide, not all of them, but several. In Ohio, that was adopted in 2017. So that solely attendance or non-attendance cannot be a basis for suspension, expulsion. That's one of those situations where you just look at the adults involved and you say, well, duh. You know, if a student can't make it to school, the solution shouldn't be suspending them from school. So I think that's been a positive change. Now, if we go forward one slide, Renee. So many of those things, and I should mention too, that the limits on suspending primary students, so K through 3 in Ohio happened fully. It was rolled out slowly, but happened fully in 2023. So it was relatively recent. But despite all of those things I just mentioned happening over the last decade and a half, the rates of suspension expulsion bounced right back up. And so the question is, like, why is that happening? Again, I will say that 3.7 to 2.1 is kind of a false bottom. I think really where we would have ended up would be closer to the 3.7 without COVID. But nonetheless, we're still now from 1973 to 2023 at twice the rates of suspension expulsion. And that's despite all the things I just mentioned. Okay, let's move to the next slide. So the question is why? Let's move to the next slide. I will say before we get into the reasons that these are theories of mine and theories of others. So far, we don't have data specifically to know why, but this from our experience in representing hundreds of students in suspension expulsion hearings and looking at theories from other educational advocacy groups are what we believe are the main reasons that students are finding themselves removed from school. So number one is cell phones we call them evidence gathering machines. They are recording everything that happens, conversations, they're recording fights, they're recording conversations, they're recording arguments. And if you do this type of work, disciplinary work, you know that often you walk into a suspension and expulsion hearing and Exhibit A is something that the student themselves created on their phone. It could be a social media post, it could be a text with a friend or to a boyfriend. It could be something on a messaging app. And again, like I mentioned, it could be a recording that the student made or even one of their peers made. And beyond phones, schools and school buses now are equipped with lots of cameras. So it's another way that evidence is being gathered. But in particular, I don't think students understand or appreciate that the thing that they're carrying in their pocket is the thing that will most likely create the evidence that will be used against them in a suspension expulsion hearing. So I think it's important to communicate that to our clients, to our children, to our populations we work with, because that's happening and I don't think there's an appreciation for it. Another thing that's happened related to cell phones, you might know this, it's changed a little bit in Ohio just very recently, but prior to COVID, most school districts addressed the use of phones in school by prohibiting them in some way, whether it was in the classroom, sometimes during lunch and recess, sometimes in school altogether. And then lots of schools got relaxed about that during COVID because parents wanted to be able to communicate with their children about whether school was in or out, so on and so forth. So the rates of students possessing phones in schools went right back up. Now, Ohio just passed a law that went into effect last school year that districts had to adopt a policy. It's their own policy, and what they do with it is up to them. But as to how students or how they will govern phone use in school, and a lot of them largely prohibited the use in the classroom. Some others went farther and required students to put them in little bags and check them in basically before school starts. But the phone use did go up during the course of COVID. So in my generation, of course, I didn't have a cell phone in high school or college, thankfully. And, you know, when we would make a mistake or say something stupid or act immature or, you know, act like a 15-year-old, that information wasn't recorded in any way, thankfully. It went out into the air and floated away. And unless somebody reported it, which again, it was only a verbal report because there was no evidence of it, that information couldn't have been used against us for suspension, expulsion. It's just a different world now, and everything is recorded for better or for worse. And it's not just students who are using phones in this way. It's not because of their generation. Us parents are using them in the same way. Our recordings are being documented, but we're not subject to school rules, and we're not subject to some laws that we're going to talk about in the same way that students are. So it's not an age thing. It's just a generational thing that all conversations are recorded. Okay, next slide. All right, the other thing is, number two, in the last 30 years, really in the last 20 years, there have been significantly heightened obligations of schools. So in 2013, and this is roughly the time that schools across the nation were adopting bullying policies, schools were required to address bullying, or it was a nationwide effort for schools to address bullying given the number of students who had harmed themselves or committed suicide because of bullying. So again, that's relatively recent. Prior to that, in my generation, again, bullying was fleeting. You know, the principal would maybe have a conversation with the alleged bullies, and that would be about it. Sometimes if something was overheard or caught, a student would get in trouble for that. But largely, now schools have an affirmative obligation to prevent bullying. And that includes, by the way, at least in Ohio, the identification of a compliance officer to investigate bullying, and then the requirement that after the investigation's done, there's some outcome or discipline if the bullying is substantiated. Similar in Title IX. Now, Title IX has existed, as you learned yesterday, for 50 years, 50 plus years now. But the Title IX regulations that were adopted in 2020 affirmatively required schools to conduct investigations with an independent investigator and conduct investigations which ultimately are determined by a separate decision maker and the appointment of a Title IX coordinator. Now that occurred that obligation existed through U.S. Department of Education guidance prior to 2020, but it became codified in 2020 where schools through the statutes, through the federal law, had an obligation to address specifically sex-based harassment and assault. And with the Title IX as it existed prior to that, really prior to the 2015s when some guidance was issued, was really just a gender discrimination statute as it applied to the application of athletics in K-12 and colleges. That has been added now. So we have all these obligations, these mini investigation obligations on the part of schools. Now we've talked about school shootings. There's now active shooter drills that we do. Schools are required to create safety plans in the case of an emergency. And the mere fact that these things have happened over the last 20 years are putting schools on edge and giving them an affirmative obligation to address situations where there is at least a plausible threat, sometimes when it's not plausible. But That's just an obligation that didn't exist. As Ruth had mentioned, um, we've had 500 deaths since 2000 in school shootings. And if you include Columbine, which happened in 1999, we have, add 14 more there. So a significant number of deaths and in part obligations, state requirements for schools to address situations which could lead to school threats. Child abuse is on here. When I have this report abuse sign, it refers to child abuse. Now that's the longest lasting obligation of educators that's on the list here. I had read that since all states in 1967, by 1967, had mandatory reporting requirements. So that's existed for a long time. It's just there, and it just coexists with all of these other obligations. And then, of course, we talked about threat assessments in 2024. Ohio required that threat assessments are done for any student who articulates a threat or they deem might be a threat. And that's just another obligation. And as you saw, it's another opportunity for schools to identify a student rightfully or wrongfully as a threat. So schools have affirmative and heightened obligations that they just didn't have 20 years ago, certainly 30 years ago. So it's a different world for how schools have to respond. Okay, next slide. Another reason is we see these mixed cultural messages to youth today. We talked already a little bit about school shootings. Not only do school shootings happen to the extent that they didn't happen 3 decades ago, but we also talk about guns as adults. It's on the news. Gun rights are talked about because of these shootings that happen in schools and elsewhere. Death is talked about. The risk of a school shooter or a mass shooting is talked about everywhere. But on the flip side of that, we have seen, and you've heard already in this conference, that we have students disciplined because they say something like, oh, I could kill her, or I'd shoot him, or I'm going to end you, or, I'm going to hurt you, or I'm going to murder her. Things that kids might say, not seriously, now have to be taken entirely seriously because they live in this culture where there's a school shooting every so often. So it's a little bit, it's a mixed message because we as adults, I can sit here today and talk about school shootings, the environment, but students sometimes in class can't have that same candid conversation for fear of saying something about guns or shootings that might get them in trouble. By way of example, we had a client who seemed to have some, black mark on his back in terms of what the school thought he might be capable of. I mean, I think about every school has someone that the other students define or nickname as the school shooter, somebody who might be a little bit odd, or maybe they've mentioned something previously or been disciplined previously, for saying something out of bounds regarding shootings. But this particular student, he was a high school student, was just having a conversation in his class about gun rights. And because he happened to be, the weird kid, at least in the eyes of the other students, he said something like, well, I can get a gun. I have that on there. And he was right about that, by the way. He could get a gun. But people took that as some type of threat because he happened to be, what they perceived as a little odd. So, I mean, we have the privilege of being able to talk about these things, but students, or at least minors, do not, at least when it comes to on school property. Okay, so the other thing, we've talked, I gave you the story about Tessa, but with sexting, there's a real problem with how our sexting laws are applied. And if you know this, if you defend students in juvenile court, you know what I'm talking about. If you defend students, at school, you know what I'm talking about. So with Tessa's situation, she was a picture was elicited from her, and she sent one, and she was subject to a misdemeanor and potentially a felony for that activity. And that's because all sexting for minors is adjudicated under child pornography laws, which is antiquated. It's wrong. It sends the wrong message, and it's way too harsh. But she was in a rural county where they took that seriously, and it wasn't an easy way out of juvenile court just by saying that she made a mistake. It was the distribution under the law, in most states, by the way, of child pornography, because she was a minor. If she were an adult and sent that, there's nothing wrong with it. She could have sent it unsolicited as an adult, and there's nothing wrong with that. It's just different rules for minors and different rules for when you're at school. If she would have sent that to a student who didn't attend her school, then she wouldn't have been subject to the jurisdiction of the school. Now, if she sent it to another minor, same issue, juvenile court. And then the same is true with marijuana. Now we have 24 states who recognize the right to smoke or ingest recreational marijuana. That wasn't the case when I was in high school, for sure. That's been relatively recent in the last decade. We have 40 states who recognize medical marijuana. And then, in some of these states with recreational marijuana, growers and distributors are like sponsoring festivals. We also have minors who, of course, whose parents, may ingest in some type of THC or marijuana at home and don't see any problem with it. But of course, when you get on the school property, it's sacred. We'll talk a little bit more about that. And it's not easy to understand. I do recall when, I had the occasion to watch Michigan go through the recreational marijuana law change, and then also a few years later, Ohio go through it. And I remember all of these legal presentations and CLEs that we would go to about, well, what that means for use of marijuana in the workplace or in school, how that might be different. Even though you can do something outside of school, you may not be able to have that same right, of course, in school or at work. But, our children didn't get that webinar. We did, and it was because we wanted to sort through it from a legal standpoint. But they haven't got that information. They know it's different. They may know for the most part, but it may not be understandable or reasonable to them. The same with the sexting laws. It just may not be reasonable for them. Okay, let's move to the next slide. So if we just look, and one more, Renee. So if we just look at what made this a problem for Tessa, first of all, she acted her age. So she made a mistake at the urging of her boyfriend. It's happened forever, but that mistake was recorded forever. What she did, though, because she sent this to another student in her high school, by the way, the school had an obligation to address it under Title IX. They had an obligation to send it to the juvenile court because it was a crime and potential. And oddly, this comes up a lot, even though you have two minors interacting in a consensual way, it has to be reported for child abuse purposes because it's a sexual picture sent. And most schools take that approach. So now reporting to the police, you're reporting to the child abuse reporting, hotline or agency. But what if she was an adult? She wouldn't be subject to any crime. She wouldn't be subject to any discipline whatsoever if she was just an adult. That's contradictory. We shouldn't charge our minors with crimes that adults themselves, if they engage in the same behavior, won't ever be charged with a crime or be subject to discipline. In fact, it's a kind of protected activity if you do it privately as an adult. But she didn't realize also that she was creating the evidence that might be used against her, and that evidence would exist for a very, very long time.
Hey, Mark,
But
that's
here's
your
the theme.
10-minute
Yeah.
warning.
Oh,
Sorry.
wow. Okay. Yeah. This is the theme, though. So we have a student acting their age, giving the school jurisdiction, which is an important point that students don't understand, and creating the evidence. So let's go to the next slide. Another example of this is Travis in the trash can. So also not Travis, but this is the name he's got for today. So Travis was a client of ours. He was a high school student. He was asking in class, he attended an affluent suburban high school in class, and he had asked through an old school note to whether or not this girl in class would go to the homecoming dance with him. Travis, by the way, was on a 504 plan. He could leave the classroom when he felt frustrated to go blow off some steam or go to the bathroom if he needed to. So he had that accommodation, and the teacher knew it. When the girl sent the message back to him, the little note, it said, "No way," something to that effect. And so Travis was a little bit upset. He got up, he walked to the bathroom, not an issue. Teacher let him go. But when he was in the bathroom, he took this note, little piece of paper, and threw it in the trash can, which would not have been a problem. Except before he did, he lit it on fire and threw it in the trash can. And then the good news is it went out before it even hit the bottom of the trash can. But the only reason I know that is because he posted it on Snapchat to a group of a small group of friends. And he said something like, "I hate this place. I hate this school," something to that effect. It really wasn't a danger. You know, of course, you shouldn't light pieces of paper on fire and throw them in the trash can, but it didn't catch anything on fire. But he posted it to a group of friends. He created the evidence, which was ultimately used against him to send him for suspension with a recommendation for expulsion. Now, if Travis would have done that, first of all, if he would have done it and not recorded it, he would have been fine. If he would have done it across the street from the school, there's nothing they could do about it. Even if he recorded it, for that matter. If he would have done it in his driveway or his neighbor's driveway, there's nothing, it's not a crime. There's nothing you can do about it. He didn't realize that it gave the school jurisdiction because he did it at school. And then he, of course, created the evidence on his evidence gathering machine. So next slide. So he acted his age, he gave the school jurisdiction, and he created the evidence. Okay, next slide. Here we have Desiree the Destroyer. Desiree is an 11-year-old, and she attended school in a suburban district, but a pretty conservative suburban district. And she had a test the next day, and the next day she was texting with a classmate of hers, also 11 years old, by the way, a boy. And she didn't want to take the test, and neither did he. So she said, we should just destroy the school. I think of my son, who's 10, almost 11, and he would say that, you know, if he didn't want to take a test. If he said it at home, it just goes into the ether, and there's no problem with that. But she, of course, texted it. And somehow the school got hold of this text, and Desiree found herself with a suspension, recommendation for expulsion. So she's a 5th grader. We're talking about a 5th grader who was recommended for expulsion for saying, "I want to destroy the school." Not a threat, not deemed a threat, but ultimately faced the suspension and recommendation for expulsion, and was referred to juvenile court in a county where the prosecutor takes a zero tolerance approach to any threat at school. So now she's got to face, as an 11-year-old, this potential misdemeanor charge, thankfully misdemeanor, when she had no idea what she was saying. In fact, in the text string, the male student, 11-year-old, said arguably worse things. about what they would do to destroy the school. But Desiree found herself in that situation. Next slide. Same pattern, acted her age, gave the school jurisdiction, created the evidence. All right, since we're going right into the Q&A, I'm going to take a little bit more time. I hope that's okay with you, Renee. But I'd be glad to answer some questions during the Q&A. I'm on the panel.
That's fine with me.
Thank you. And I just have a couple other examples here, but now Henry was a middle school student at a Catholic school. So this is a little bit different. If you represent students as an advocate or as an attorney, you know that private schools are a little bit different in the way that we advocate for our students. This in particular was a parochial school, Catholic, and what happens in private schools or non-public schools is that they make the rules and they may or may not enforce them. You start with a contract where the parent signs and says, okay, we're going to pay X amount of dollars to send our kid to private school. And that contract says most of the time you can be dismissed for any reason or no reason. There's no refunds, something pretty one-sided in those contracts. Then you have a student handbook. Now with a private school, they can, make the rules they want. No real First Amendment limitations unless they adopt them themselves. But, in this case, Henry couldn't have his hair, or any student couldn't have their hair on their neck or in their eyes. And Henry's hair was on his neck. And the female principal was giving Henry a hard time over the course of, several weeks about getting his hair cut. And so finally she said, if you don't get your hair cut tonight, you're going to get a detention for every day that you come to school with that hair. So Henry went with his mom. They drove to the hair cutter place. He got his hair cut and he hated it. So he's in the car with his mom on the way home from the haircut, and he texts his friend, which did not attend this particular school, and said, my hair looks terrible. I'm going to kill my principal. Not meaning he's going to kill his principal, of course. So his friend, his mom got a hold of that somehow. I don't know if she showed it to him or what. But before the night was over, at around 11 p.m., the law enforcement showed up at Henry's door and with the text and said, this is a threat against the principal. He was facing juvenile charges for a school threat. He was immediately expelled with no due process because that's how they can do it in a private school, for violating, the parochial school rules. And there was nothing we could really do about the expulsion. They said, if you threaten the principal, then you're out. But he now, a middle schooler, was facing the juvenile charge, thankfully in a county where they were allowing a diversion. They don't have a zero tolerance policy. They put things in perspective. So in this case, he ultimately had to go through the diversion program, which included, several conditions, but he did. But what did he do here? If you go to the next slide, he acted his age. He gave the school jurisdiction because he was talking about his principal. Don't talk about the principal. Don't talk about your classmates. Don't give the school jurisdiction. Now I'm using the term jurisdiction, by the way. That's roughly the equivalent of what courts have. But schools only have an obligation to address it if it puts other students or staff members in danger, or yourself, of course. So otherwise, in a lot of cases, that's where if you're, we heard about the cheerleader case yesterday from Kathy, where she said, F school and F my coach or something like that. And that wasn't a threat. She did that off campus. And even though she had mentioned the school, it wasn't a threat. They didn't have to address it. And in fact, it was protected by the First Amendment. So here, because it's arguably a threat, he gave the school jurisdiction. He didn't know that. If he would have said, I want to kill my neighbor, I doubt that he would be facing criminal charges. I don't think that's enough to get there. So, and he created the evidence, of course, just by sending a text message. So this is the pattern that comes up over and over. We'll quickly go to the next, go 3 slides up. One more. Yep, right there. How about, so Carson. Carson posted this online, not something like this, not this exact one. He didn't say anything except, if you know, you know. He posted this album cover or something with a bullet on it or ammunition, and somebody's parent saw it and they reported it to the school, and he found himself, with a suspension, with a recommendation for expulsion. It arguably had nothing to do with school. But he had already been labeled as, kind of a strange kid. So it got reported. Luckily, we were able to avoid the suspension by talking through it and expulsion, by talking through it with the school. But next slide, same thing. He acted his age. He was a high school student, by the way. Gave the school jurisdiction, created the evidence. He just posted on social media. He legitimately, thought it was about the music for him. He loved music. He loved the artwork on album covers. And he said something so vague that it could have been interpreted as a threat. So because it was reported by a parent, we argued, of course, that the school had no jurisdiction over that. But, and I don't know that we were successful other than we avoided the suspension and expulsion. But that's a situation where it could be a little bit gray as to whether or not the school has any authority whatsoever. I would argue certainly, and we did, that he didn't in this case. Okay, so let's go on right there, yeah. I had a couple other examples, but it falls into the same category. They acted their age, they gave the school jurisdiction and created the evidence. And so next slide. I guess the summary in all of this in terms of why student suspension expulsion rates are going back up. I would hope that it's going to plateau at roughly, twice the rate from 1973. Let's hope so, given some of the efforts. But we as attorneys and advocates and parents are uniquely positioned to help students understand these things: the current culture, how to accept the realities and hypocrisies of their time, and that school is sacred. You can't give the school jurisdiction or a reason to punish you. One other big hypocrisy that I want to point out, which I forgot to mention with Tessa, is that what does that tell Tessa? Sexting is flirting for students, rightfully, whether it's just a reality, whether we like it or not. Sending a picture of you, topless, whatever, is a step that reasonably comes before having sex. It is flirting, that this couple had not had sex, that came out. But she agreed to do that. But if they would have, remember they're 15 and 16 years old, if they would have been at home, of course, they can't do this at school, or it gives the school jurisdiction. If they were at home and had sex, there's no crime, there's no jurisdiction that the school has. It's in some ways encouraging younger students to engage in the act. It's not a crime if you're within 3 years of each other and you're over 14. For most states, that's true in Ohio. So it seems less safe, or I'm sorry, less risky from a student standpoint. That is a hypocrisy. And of course that it doesn't, as adults, there's no crime whatsoever, and in fact, protected speech if we engage in the same sexting behavior. So anyway, those are just a few of the things that I think students are dealing with today, and part of the reason that rates are going up. So I'd be glad to take some questions. We can take a break, and I can take those on the panel if needed.
It looks like I'm trying to, there we go. There was just a comment that schools are freaked out due to liability and the examples listed are ridiculous and students are being treated in an overly harsh manner. And that risk assessment and desire not to be sued is driving this as well.
100%. It's
Yeah.
just, yeah, right on point.
So,
The-
oh, go ahead.
Mark, we did have a comment to add to your comments. I think that the high stakes testing is deeply intertwined and mutually reinforcing with school push out. I blame the No Child Left Behind Act and its legacy for leaving more children behind. I also think it's been obvious that connecting schools' funding and school administrators' jobs to testing data was always going to lead to new and increasingly creative and evil ways to push out the problem kids.
Yep. All of those examples on the poll that we took are other reasons that discipline rates may be going up. So I don't want to discount mental health. I don't want to discount schools' liability, and they're trying to avoid liability. I don't want to discount standardized testing. All of those things have an impact. We kind of boiled it down to 3 here, but those are good comments on the same token.
Well, I'm going to stop us here and give us a little bit of a break before our final panel of questions and answers. I know we've got some in the backlog, and so if we just have one more comment, great presentation. If there are any questions about Mark's presentations, any presentations that were done today or yesterday, or any education or special education related questions, feel free to start dropping them in the Q&A, and we will be back at 4 o'clock in just a couple minutes to introduce our panel for this afternoon and get underway with answering those questions.